Good evening, friends. It is my great privilege to welcome you all on behalf of Nani Palkewala National Law Club. Today we have a Advocate Supreme Court of India, Jayprakash Somani sir, founder director of Nani Palkewala National Law Club. And in this web series, we are going for the Recruitment Matters. This is the first web series after we have celebrated 105th anniversary of Nani Palkewala on 16th January at Supreme Court of India. Over to you, sir.
Thank you, Marg, for introducing me. Friends, now we'll see on recruitment matter 15 judgment and in 20 minutes. But before applying 20 minutes, I want to give some information regarding the Supreme Court's stand on recruitment matters. So I will elaborate some 12 points on that, and then I will initiate our further process of giving 15 judgment in 20 minutes. And at the end, as usual, I will give some tips on successful advocacy, how you can become a successful advocate. At the end, some tips I will give as usual. In every episode, we are doing that. Because this series is only for lawyers and law students. So who are interested in practicing in litigation directly in any court, in tribunal, in trial court, in district court, at tehsil court, or in high court, or in Supreme Court. The Supreme Court of India has provided various rulings and judgments regarding recruitment matters over the years. Here are some key points that encapsulate its stand on this issue. 1. Merit-based recruitment. The Supreme Court emphasizes that recruitment to public services should be based on merit, and any system that introduces bias, favorism, or corruption undermines this principle. So this is a very important point of the focus of Supreme Court. Second significant point, right to equality. Article 14 of the Constitution guarantees equality before the law, and the court has frequently affirmed that recruitment processes must be non-discriminatory and transparent and ensuring equal opportunity to all candidates. Third, selection criteria. The court has ruled that any criteria laid down for recruitment must be rational, reasonable, and justified. Arbitrary selection criteria are subject to judicial scrutiny. Point number 4, reservation policies. While the Supreme Court upholds the reservation policy for SC, ST, and OBC candidates as a means to promote social justice, it also stresses that these reservations should not violate the merit principle or create an imbalance in the workforce. Point number 5, judicial review. The Supreme Court maintains that it has the authority to review the recruitment process to ensure adherence to legal standards and principles of fairness, especially when there are allegations of irregularities. Point number 6, role of selection committee. This is the most significant point. Whatever injustice is caused because of the fraudulent things which takes place while the recruitment process. So, role of selection committee. The court has delineated the responsibilities and powers of selection committees, indicating that their decisions should be based on established norms and procedures. Point number 7, challenging recruitment notifications. The Supreme Court has allowed candidates to challenge recruitment notifications that lack clarity, transparency, and may be arbitrary in nature. Point number 8, time-bound recruitment. The court has often criticized delays in the recruitment process and has mandated timely completion of the recruitment to ensure that candidates do not suffer prejudice. Point number 9, skill and qualification. In its judgment, the court has highlighted that the required skills and qualifications for any position should be clearly defined and adhered to in the recruitment process. Point number 10, impact of policies and regulations. The court distinguishes between policy decisions made by the government and the regulations of governing the recruitment process, indicating that policies should not be undermine statutory rules. Point number 11, professionalism in selection process. It emphasizes a professional and systematic approach to selection process, recommending the establishment of clear guidelines and adherence to ethical standards. And point number 12, accounts of post precedents. The Supreme Court often referred past judgments to reinforce its stance and ensure consistency in its ruling on recruitment matters. The Supreme Court stand on recruitment matters has been instrumental in shaping fair and just practices in hiring for the public services, ensuring both compliances with the constitutional provisions and the promotion of meritocracy. So it is my pride privilege while I am practicing in Supreme Court of India, I am handling so many service matters. And all matter, near about all service matter are related to many of them related to recruitment process. So now I'm presenting you 15 landmark judgment. Now you can keep watch on time. Within 20 minutes, we have to finish this 15 landmark judgment. Here are 15 landmark judgment of Supreme Court of India related to recruitment matters, summarizing the facts, decision, ratio decidendi, and citations. 1. State of Uttar Pradesh versus Rajkumar Sinha, AIR 1997, SC 2000. Facts. Dispute over recruitment to the post of assistant teacher. Decision. The Supreme Court held that the recruitment process should be conducted fairly and cut-off mark should be consistent. Ratio decidendi. Fairness in recruitment protects the right of the candidates and maintain the integrity of the selection process. Citation of this case, I am reiterating again, AIR 1997, SC 2000. Case number 2, Krishan Yadav versus State of Haryana, AIR 1994, SC 2885. Facts. Concerned over recruitment of sub-inspectors, which included physical eligibility tests. Decision. Recruitment must adhere to notified criteria and any changes need to be communicated well in advance. Ratio decidendi. Transparency in process prevent arbitrary action by authorities. Citation. AIR 1994, SC 2885. Case number 3. Union of India versus MLK Kesharwani, AIR 2014, SC 2198. Facts. Challenge regarding invalidation of examination for all India services. Decision: set aside the decision of invalidating the examination. Ratio decidendi: an examination could not be annulled. Annulled means cancelled unless there are compelling reasons that compromise its integrity. Citation: AIR 2014 SC 2198. Whatever cases I am giving you here, near about 90% cases are in favor of the candidates and against the government or private respondent bank, like that. Then case number 4, Jagdish Lal versus State of Haryana, AIR 1997 SC 2386. Facts: recruitment policy and age limit challenge. Decision: held that age relaxation rules should be uniformly applied. Ratio decidendi: equal opportunity must be provided to all eligible candidates. Citation: AIR 1997 SC 2386. Case number 5, SB Ora versus Union of India, AIR 1999 SC 2007. Facts: inconsistency in recruitment criteria challenged by selected candidates. Decision: the Supreme Court directed recruitment to be based strictly on policy as framed. Ratio decidendi: non-adherence to set criteria undermines candidates' rights. Very good. Citation: AIR 1999 SC 2007. This video will be uploaded shortly within 24 hours on YouTube, and that link will be shared in our Nani Palkiwala National Law Club's official groups. If you are a member of that official group, then you will get the link of that video, and anytime you can watch this video, you can note down this citation, everything, nothing to, not to worry. Then case number 6, Director of Education versus Pramod Kumar, AIR 2000 SC 1930. Facts: dispute regarding selection of teachers, the wrong process was followed. Decision: the court upheld the selected candidate's right to employment, emphasizing proper procedure. Ratio decidendi: adherence to procedural fairness is critical in recruitment process. Citation: AIR 2000 SC 1930. Case number 7, Madhya Pradesh Karmachari Sangh versus State of Madhya Pradesh, AIR 2006 SC 1305. Facts: challenge regarding the method of selection and appointment in a government department. Decision: reaffirm the need for transparent recruitment process. Ratio decidendi: transparency and non-arbitrariness are essential for a fair recruitment process. Citation: AIR 2006 SC 1305. 8, S.R. Tiwari versus District Board, Agra, AIR 1964 SC 1680. Facts: review of appointment to post in local bodies. Decision: emphasized adherence to the lawful method of appointment as prescribed by rules. Ratio decidendi: compliance with statutory rules in recruitment is mandatory. Citation: AIR 1964 SC 1680. Case number 9 is very landmark case. Indira Sawhney versus Union of India, AIR 1993 SC 477. Facts: challenging to the validity of reservations in recruitment. Decision, the Supreme Court upheld that the 27% reservation for OBC categories, but capped it at 50%. Ratio decidendi, reservation policies must balance affirmative action with merit. Citation AIR 1993 SC 477. Case number 10, Kalyan Singh versus State of Uttar Pradesh, AIR 1991 SC 2072. Facts, appointment of teachers faced issues with eligibility and selection methodology. Decision, the Supreme Court upheld that teachers must be selected based on merit and fairness. Ratio decidendi, selection must be merit-based to ensure equality in education. Citation AIR 1991 SC 2072. 11. Vishaka versus State of Rajasthan, AIR 1997 SC 3011. Facts, sexual harassment at workplaces and implications for recruitment policies. Decision, laid down guidelines for preventing sexual harassment and ensuring a safe environment at workplace. Ratio decidendi, safe working environment are essential for fair recruitment. Citation AIR 1997 SC 3011. Case number 12, MC Mehta versus Union of India, AIR 2004 SC 3428. Facts, recruitment in various government services scrutinized due to procedural improprieties. Recruitment in various government service scrutinized due to procedural improprieties. Decision emphasized the need for due process in recruitment to uphold constitutional values. Ratio decidendi, fundamental rights of candidate must be protected through fair practices. Citation AIR 2004 SC 3428. Case number 13, B. Ramakrishna versus State of Karnataka, AIR 2009 SC 1901. Facts, recruitment rules being unreasonably modified to benefit particular candidates. Decision, the Supreme Court mandates strict adherence to fair recruitment norms. Ratio decidendi, illegitimate changes in recruitment rules undermine the principle of equal opportunity. Citation AIR 2009 SC 1901. Case number 14, Union Public Service Commission, that is UPSC, versus A. Manohar Reddy, AIR 2008 SC 1959. Facts, selection process by UPSC challenged by candidates claiming discrimination. Decision, set aside discriminatory policies and preserved students' right for equal opportunity. Ratio decidendi, equal treatment in recruitment process is essential for fairness. Citation AIR 2008 SC 1959. Quote number 15, Hindustan Zinc Limited versus AJVS Sharma, AIR 2005 SC 2147. Facts, concern over the recruitment and promotional procedures in a PSU. Decision, the court upheld the validity of recruitment based on the merit and the adherence to prescribed policies. Ratio decidendi, fair recruitment policies in public sector undertaking reaffirm the merit-based promotion principle. Citation AIR 2005 SC 2147. These cases illustrate the Supreme Court's ongoing commitment to ensuring fairness, transparency, and adherence to lawful procedures in recruitment matters within India. So, friends, I hope I have completed this within 20 minutes, 15 judgment with citation, facts, decision, ratio decidendi. So everything we try to cover that. And it is very easy to find you the full judgment on Google platform or on any website also. So friends, the last part of this presentation is, just give me a few seconds to give some tips on successful advocacy. So wherever you are practicing, and if you want to become a master, a best lawyer in that, best renowned lawyer in your area, so you should daily read at least one judgment of your concerned appellate court. Suppose if you are practicing within a state, okay, and in district court up to district court level, then one case of High Court or Supreme Court, you should read it. And if you are practicing High Court, one case of High Court and Supreme Court, you should read it. 2 cases daily. Reading the cases, reading the judgments is art. No need to read whole judgment. Just read starting part, understand the facts, understand what is the contentions presented by the petitioner, understand what are the contentions presented by the respondents, and what are the conclusion of the judgment. Middle part is so large sometimes by giving different citation like that. Given the para of that citation, you can read that also. Okay, but reading the judgment will enable you practical application of law. So this is my special guidance to become a good advocate. So daily, without sleeping, without reading, don't go for sleep. So while you are going on bed, before sleeping, just remind me, अरे सोमानी सर ने बोला था हमको, we should read one judgment before sleeping. Then read judgment and then sleep. So, and continuously, without fail, you try to imbibe this rule in yourself. Without fail, in any day. Don't give holiday on Sunday also to this process. Then see what miracle happens in your life. So, over to you, Manoj. Just. Hold on. I will. Now unmute yourself and then conclude.
Thank you very much, sir, for such an guideful advocacy that read the judgment, one judgment daily, and you have given the time management of that, since you will sleep every day and you know that you have to sleep. So just before sleep, you take your judgment and read that. That is a very helpful. Thank you very much, sir. Thank to all the participants who have got this motivational, and we're looking forward to join another webinar. Thank you very much. Over to you, sir.
Thank you.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।